The Honourable Member for Nelson.
Thank you, Mr President. I rise to speak on this Residential Tenancy Amendment Safety Modifications Bill for 2025 in absolute support of the quite straightforward, sensible and much needed, probably somewhat tardily brought to this place, amendments that it puts forward. Of course, it makes entire sense to empower tenants to be able to make minor modifications that relate to making their home safer, particularly for children, when it comes to tethering furniture. I appreciate the contribution made by the member for Mersey and the questions he raised there around electronic devices like large TVs and whether that's captured here. It's important to have clarity on that. I think we'd all be well aware of the potential there for there still to be accidents if that's not included. I think it's useful to have a nice, clear precedent set here in what the government's brought forward that shows how sensible it is to make sure the balance is right between tenants and what they need to do to make sure their home is appropriate for them and safe and secure and accessible, and landlords who are the owners of the properties. Mr President, in my view, and I thank the member for Hobart for her contribution, she spoke about this in some detail and I won't go to as much detail, but I do speak along similar lines and in support of what the member for Hobart put forward, and that's that if we're doing it in respect to minor safety modifications here in this bill, of course, the exact same principles apply to those other areas around security, around accessibility, and for Tasmanian tenants who are in a horrifically disempowered situation in our current catastrophic failure of the private rental market in Tasmania. For vulnerable tenants, it's incredibly difficult to ensure that they are able to live in a secure, accessible, appropriate home while they're tenants and have the current restrictions that they face when it comes to something as basic as an accessibility aid of some sort that would in fact make their lives immeasurably safer and easier, but they can't potentially do. And certainly if the landlord, for no particularly good reason, tells them they can't. That's absolutely a nonsense, Mr President. And in the market we have now, the private rental market, catastrophic failure, functional market, and it's worth repeating this every time we speak about this issue that touches into our private tenancy market. Mr President, a functional private rental market is a vacancy rate of 3%. That's absolutely categorically factual. What we have and have had for a long, long time is a vacancy rate of less than 0.5% or thereabouts. Certainly nowhere near a functional vacancy rate. What that means is that as a tenant you live in fear. You live in fear every day. If you are lucky enough to be in a private rental arrangement, private rental tenancy, you are absolutely petrified that it's going to come to an end, because if it does and you'll be having to find a new tenancy, you'll be really facing an uphill battle, particularly if you present anything that might be challenging to a new landlord to contemplate. Because landlords hold all the power in this situation, Mr President, with a vacancy rate so catastrophically low. Landlords absolutely have their pick of tenants, and they do not need to contemplate anything that might be a little bit challenging when it comes to a tenant, whether that means the person has a disability that might need to have adjustments made, whether the person may even be as simple as that they have a number of children or they have particular pets or they have whatever. Of course, the landlord can't discriminate against them on that basis, but the landlord has all the choice in the world when they know that they're going to have such a large array of people applying, they can take their pick. I'm not saying that to cast aspersions on landlords. In fact, Mr President, I am a landlord and have been for a while. I'm also a renter, and I know that when I turn up to put an application in for a rental, I'm probably going to be pretty high near the top of the list to be accepted for it because of the position I hold, because of the income I'm privileged enough to have, etc., etc. But for so many Tasmanians, and I can think right now of young people that I know, a young person, a group of young 19-year-olds trying their best to begin their adult life and move out of home and into independence, which in our day, Mr President, was not necessarily difficult to do from the perspective of there being properties available that we could afford to rent, even on a government payment that we might be getting. That's not the case now. And any young group of Tasmanians who are trying to take that big step into adult life and independence away from their family will find it very difficult to be chosen as tenants, Mr President. So in that context of the absolute failure of our private rental market, the absolute disempowering of tenants who live in fear of maybe having their tenancy come to an end and then not be renewed, having to find a new home, having to face the prospect of homelessness, and we know many Tasmanians are in fact exiting the private rental market into homelessness at the moment. We should be looking for every way we can to rebalance the power dynamics here, to recognise sensible, appropriate, particularly safety and security and accessibility measures that can be put in place and made available to tenants to at least address amenity issues in their home, that they don't have to jump through every hoop under the sun or be at risk of being turned down for particular sorts of modifications or changes that are just being rejected on no reasonable basis, but because the landlord doesn't want them to do it and doesn't like it. Mr President, so on that, I'm really pleased that the member for Hobart is bringing amendments for us to consider. I think it will be interesting for us to address them should the bill go through to committee stage and have a conversation around that. It's really disappointing to think that they might be dismissed out of hand without due consideration. When I look at those amendments, I see a lot of thought has gone into ensuring appropriate protections are there from both sides of the equation. So I really encourage members to have a good look at those amendments and don't just dismiss them outright. And I think it's a reasonable step. I actually also think we're inevitably on a path towards where the amendments take us. We will get there. It's actually just absolutely a shame to think that we don't take the earliest opportunity to get there, which would be in this bill, that there would be any suggestion we should be waiting for an overarching review of the Residential Tenancy Act, which of course is well overdue and needed, but when it comes to a bill that already presents us with a very straightforward, sensible model for safety modifications here, to also contemplate similar other allowance for modifications on the basis of accessibility or security, etc., is entirely appropriate and I think merits attention and support. So on that, Mr President, I will of course be supporting this bill. I'm also very much inclined to consider and support the amendments that have been foreshadowed with us and provided to us ahead of time to have a good look at. I think there was one question I was going to ask on a matter that came up during briefings, and I will think to put it on the record here so the government could, it's a very simple one, could provide a little response to. I think it related to when the tenant is moving out. So I think it's probably related to clause 6 of the bill, and which it relates to 54A, safety modifications permitted, and it's the part that is subsection 6 here, where a tenant may remove any safety modification that the tenant has made to the premises unless the removal is likely to cause permanent damage to the premises. What I wanted to have some clarity around is it in fact the tenant's up to the tenant to choose whether to remove or not, or are they obliged to attempt to remove if it's not going to permanently damage the premises? It seems like the way that's worded, it's an optional consideration in the first instance as to whether the tenant needs to remove any of the modifications that they've made as per this bill. That's, I hope, a fairly straightforward little clarification just to make here on the floor of the chamber as we debate. If it's not able to be answered in the leader's summing up, we can certainly address it when we get to the committee stage. So either way, I'm happy for that to occur. So on that, Mr President, I support the bill.